But royalty is only one species of exaction. So only royalty and section 9A are considered under the Act. There could be variety of exactions. That does
with great respect, when we talk of taxes on mineral rights, it's a narrower focus. Your ladyship is right. And we do not, unlike entry 97, the state doesn't have the competence to conjure up taxes. Parliament can conjure up taxes. As Justice Chandrachud's senior judgment in one case borrowed an expression which Justice Venkatachalaya was very fond of, ragabag laws. You can have some kind of a tax put in some way. The Madura something judgment where there was an annuity added in the income tax law, and it was challenged saying this goes beyond entry 84. This court said, of course, it goes beyond 84, but so what? And they borrowed an English expression, ragabag laws. You can put anything in any law as long as there's a law and there's a charge and there's a levy and there's a collection. It's good enough. Doesn't matter what label you put on top of it. So the important point here is state can't conjure up different exactions.
That with regard to the scheme of exaction of royalty, there is a limitation by the central law on the state's power to exact royalty.
Absolutely.
Full stop.
But it can't exact anything more.
That is the point now.
Because all the terms and conditions on which the state grants mineral rights are exhaustively enumerated in the Act. It cannot add a condition, it cannot remove a condition. And I'm going to show that. If it was just Parliament saying royalty will be so much, leaving it open, you could have said, all right, this is royalty. How about paying me some ground rent also? How about paying me some share also? No. That's why the third thing, what the Chief Justice said, the 5 points which I made, it exhaustively sets out the terms and conditions on which these rights are going to be made. So it doesn't leave it to the state to say, I can add something more.
K doesn't stop at royalty. Form K, which is the lease deed, it says any other levies, fees, etc.
Whatever is there, please collect. No problem. You can add to that word, is my point.
All right, Mr. Salve, now I think we've really understood the heart of your submission. Now, what remains now? What would you like to?
Not remain. I tell my Lord what all I have to cover. So that your Lordship will know. I'll stick to my estimate. I'll finish it. I have the points which I have to cover. I want to now, my Lord, very quickly, because your Lordship have seen the sections, make this point good by showing the provisions and correlating them to this point that it exhaustively sets out the terms and conditions. I start by saying none of them, I'm not trying to be facetious, none of them have put it in this way. But at the end, they all say the same. And I'm going to come immediately to the next point on what is the meaning after this on tax on mineral rights. That's an independent argument. And it is going to be my submission that in the constitutional context,
taxes to be levied.
You cannot construe it literally because one has to see the constitutional context and the legal framework on which this was passed. In the constitutional context, a tax on mineral rights is a tax which gives the state a share of the mineral produced. And if that is so, and royalty answers the description of a share of what is produced, then in that sense, a freeze on royalty by Section 9 operates as a limitation on your tax on mineral rights. So in that sense, royalty is akin to a tax. I'm not arguing royalty is a tax per se. That's wrong. I mean, at least my limited intellect doesn't allow me to envision how one can show royalty is a tax. But in the constitutional context, that's how I understand the entry 50 judgments. Entry 49 and 50. And that's a much simpler argument. Entry 49, I have two answers. When mineral rights are decoupled from land, you can't reach out to entry 49 to tax mineral rights. If I don't own something, you can't tax it.
You'll also have to deal with the point that, well, they're taxing land and using the mineral as a measure of the tax.
And there, my lord, fortunately for me, there is a very helpful recent judgment, which I would comment for your lordship's acceptance by a bench of 3 judges, where, my lord, for customs duty, first of all, what I call the RR engineering caveat, which came for the first time. This court said this measure can't be taken to a point where it becomes a substantive tax by itself. And then the Acer case, where this court, in the context of imposition of customs duty, said something which is non-dutiable cannot be added as a measure of duty. If something is expressly exempt from tax, you can't add it on. Now I'm saying something else. My submission is going to be twofold. First of all, my submission is going to be, as far as the measure argument goes, if you say you're taxing me on land, you can say your house, the capacity of your house to yield income. That's the principle on which we get the measure. Or the capacity of your land to yield crop. Or the capacity of your land to do all these. But can you say the capacity of my neighbor's land? I don't own my neighbor's land. If I don't own the mineral, how can you say that the capacity of your land to yield mineral will be a tax on your land when I don't own the mineral? That's one answer to the measure point. The second and more important point which I want to argue, which has not been squarely addressed, is in the context of 48, 49, 50, entries never overlap in law. There may be factual overlap, but when land revenue, taxes on land and taxes on mineral rights were separately treated, is it not clear that taxes on land cannot include tax on mineral rights? These are the two Murthy arguments. These are the two broad areas which I have to cover. I'm not going to take too much time on in India Cement versus Kesoram because if your lordships accept what I'm saying, it doesn't matter whether India Cement got it right or wrong, and if your lordships don't accept what I'm saying, it doesn't matter whether Kesoram got it right or wrong. So my first point, Section 4, the heading is enough. Prospecting under mining operations under lease, no person can undertake reconnaissance, prospecting, mining except in accordance with the terms and conditions of a permit, prospecting license as may be granted under this Act. So mineral rights are created under this law on terms and conditions sanctioned by this law and under authority of Parliament. That's why, Malad, I took your lordship's time reading those three cases. Even where the state makes rules, it makes rules as a delegate of Parliament. So 4, Malad, runs coach and 4 through any suggestion that the state as the owner has any elbow room. No elbow room left. They can't have any more conditions. They can't add any more exactions. No mineral concession. Now they've used one word, Malad, one phrase rather. No mineral concession shall be granted otherwise than in accordance with the provisions of this Act and the rules made thereunder. So, Malad, now all mineral rights are granted under parliamentary legislation. It will have some bearing on whether you can then tax these rights. The choice of a grantee, if your lordship sees 5, a state government shall not grant a mineral concession to any person unless A and B, provided that in respect of a mineral specified in Part A and Part B, no mineral concession shall be granted except with the previous approval of the central government. So it's not really the state which is granting. The state is acting under parliamentary law. And here, especially, Malad, we are really concerned with the big minerals, A and B, or schedule. It's with consent of central government that you even grant the mineral concession. And so much for being an owner. The only thing, therefore, apart from that, of real significance in the first schedule is, Malad, one understands why the federalization. The lordship just sees that for a minute, 982. Coal, lignite, atomic minerals. Malad, I'm sorry to digress. There's a case pending here, but I can give the facts. The state of Orissa, rich in coal, wanted to give a mining lease to a private company, a big private, which came and said, I will generate 500 megawatts of power. I'll give you half. I will set up an aluminum plant because you have bauxite, 10 million ton plant on which you will get GST plus excise, share of excise, and it will create 14,000 jobs between these two. The state of Tamil Nadu said, we need electricity. We need the coal. Now, if the power of taxation is there, you can tax coal, the state with its mineral rights. What happens? This is the balancing between the competing resources. So Tamil Nadu needs, it's an industrially developed state, needs power. It doesn't have coal.
Salve, we've seen some section 9. We just quickly look at you can enumerate.
The schedule, Malad, I wanted to say atomic minerals, etc. These are the kind of critical minerals which are there. Then, Malad, the whole of chapter 3, page 946. This will have some bearing on the second heading on what is tax on mineral rights. Just please see the heading, Malad. And I had made this point yesterday. What flows from it, I will develop today. Procedure for obtaining mineral concession in respect of land in which minerals vest in the government. So you recognize, my Lord Justice Pardiwala was pleased to ask me, where did the royalty go? Of course, it goes to the state. Their ownership is not touched. But chapter 3 says, I will tell you the procedure by which you will create mineral rights in yours.
All right. What is the next one?
Then, my Lord, your Lordship had already seen 10B. Now there is one provision which I did not dwell on yesterday, so I'll just take 2 minutes on that. Chapter 5.
Where does it begin?
Page 967. Your Lordship knows, my Lord, earlier there was this controversy about reservation. And the High Court held as an owner, you can always say, I will not grant. When it came here, Your Lordship said, apart from owner, really the limitation lies in entry 59 of the old concession rule. But all that is now historical. Please see 967, section 17. And that's a little important. The provisions of this section shall apply in respect of land in which the minerals vest in the government of a state or any other person. But this cuts across both. Now, subsection 3 is very important. See the degree of detail they've gone to. That's all that you pay. You can't layer mineral rights tax. Tomorrow, central government may say, we will do this, and it will do it under an operating contract, say, by Coal India or by the National Mineral Development Corporation.
Right. Which is the next provision.
Can you tax that? You can't. So, although you're the owner, nothing remains, the husk of the title remains really. You can't, a state can't even say, my company will do it. It has to be with the approval of the central government. So, first of all, it's under parliamentary law you do it, and then you do it with the approval of the central government.
Right.
Then, my Lord, section 18, just, I've read it fully, my Lord, just to give your Lordship the page 969, which is the duty of the central government, etc. And 18.2d, my Lord, specifically talks of development of mineral resources in any area. I mean, of course, the power is very wide. My Lord, my friend wants me to show 18a, that the government of India can authorize GSI to make investigations. 19 again says, any mineral concession granted, renewed, acquired in contravention of the provision of the Act or rules or order shall be void and of no effect. So, my Lord, 4 says these are the terms, and 19 says anything which doesn't comport down to the last detail is void.